What you know, Alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It's Wednesday, June 25th. It's been a hot minute since I have sat behind this microphone. A week ago, this past Saturday was my last night in Phoenix, and I was having dinner with a friend and got a call that my Grammy was sick and they were calling EMS. So I scrambled to get the very last red eye out of Phoenix. Just the worst night, y'all. You know how much I love my Grammy. Being across the country, knowing she was pretty darn sick, it was the longest night of my life. Had to go to New York City, then connect back to Greenville. And then once I got home, I didn't sleep for 2 days solid. She had a procedure done, spent several days in ICU. Then she was moved over to the heart unit and just yesterday was released back home. She's going to be just fine. It's just going to take a good while for her to get her energy back. Next week, the week of the 4th, is most likely going to be another dark week for me. We have our annual family 4th of July vacation down at my parents' beach house. Although this year my mom is going to come stay here with Grammy and she's doing well enough. I don't mind leaving her. You guys keep me in your thoughts and prayers. I am taking 4 teenage girls to my parents' beach house, but it should be fun. They're a great group and we get to celebrate Sarah Rose's birthday. Fruit Loop and Brienne are coming as well. So we may do an impromptu live and just chew the fat. Who knows? Good reminder to go subscribe on YouTube if you haven't already. And if you want notifications of when I go live or post new content, click that little bell icon. Let's jump into Lori Daybell's motion for a new trial. This is the recent guilty verdict, the attempted murder of Brandon Boudreaux. So let's see what she says. We'll start with the facts. Section A, the Fourth Amendment violation medical evaluation. On Friday, May 30th, the defendant became ill, vomiting at the lunch break during jury selection. After a lunch break, the defendant informed the judge and state of her sickness and that her investigator had been out sick since the prior day with the same symptoms. The court asked defendant to stay for 10 minutes while he informs jurors and releases people with scheduling conflicts. Defendant was reluctant and did not want to vomit in front of jury. However, the judge refused to dismiss her. The 10 minutes turned into 1.5 hours. Before being dismissed by the court, he advised defendant to let the court know through her team before Monday if she was still sick. On Sunday, June 1st, defendant was still sick and had her advisory counsel email the court to inform that she was still too sick with a virus and could not proceed on Monday, June 2nd. Monday, June 2nd, defendant was very sick and had advised the court in a timely manner. However, the court sent an order to the jail on June 2nd to have defendant brought to court by any means necessary. Defendant could not walk from being weak and dehydrated, having vomited all weekend. Maricopa County Sheriff's Office brought defendant to court in a wheelchair. Defendant then explained to the court she was too sick to represent herself and would not go forward. The court again asked the defendant to stay while he brought in potential jurors to explain and order her out of the wheelchair and into a regular chair. Defendant argued that the last time he said 10 minutes, which took over 1.5 hours, so he dismissed her prior to dismissing the jury. Defendant was left in the wheelchair in a holding cell with no blanket, medicine, or hydration for 6 hours waiting for transport back to the jail. On Monday, June 2nd, the court sent an order to Maricopa County Sheriff's Office requesting they medically evaluate defendant, a violation of this defendant's Fourth Amendment rights and Arizona Constitution, Article 2, Section 8. So what is she citing here? The Fourth Amendment protects against unlawful searches and seizures, and the Arizona Constitution, Article 2, Section 8, pertains to the right to privacy, stating that no person shall be disturbed in his private affairs or his home invaded without authority of law. And is essentially Arizona's equivalent to the Fourth Amendment of the Constitution. June 3rd, Maricopa County Sheriff's Office called defendant out of bed again to walk down to medical. The Sheriff's Office ordered CHS to evaluate the defendant's health without her knowledge. The Sheriff's Office ordered CHS, then provided their evaluation to the court through the Sheriff's Office's civil attorney, Joseph Vigil, which was a HIPAA violation, notice filed on June 3rd, initially not under seal. On Wednesday, June 4th, this court ordered again defendant to court by an any means necessary order to the sheriff's office. Any means necessary order means guards show up at your cell and pull you out of bed and take you to court against your will. Once in court, defendant again informed the judge she cannot proceed because she is too ill. Judge Boreski orders her not only to stay, but to defend herself while too sick to do so. Defendant was then forced by the court to voir dire the jury and select a jury. Thursday, June 5th, although defendant was still suffering from a viral illness, she was expected by Judge Boreski to give her opening statement and begin cross-examining witnesses. Friday, June 6th, the judge ordered defendant by any means necessary to again defend herself sick in a full day of court from 9:30 until 4:30 p.m. Sunday, June 8th. Defendant's advisory counsel again emailed the court that defendant is still sick and that she had been notified by CHS of the results of the testing performed, came back with an infection in need of antibiotics for treatment. Yet again, a by any means necessary order was entered by the court for Monday, June 9th. Monday, June 9th, the judge cleared the courtroom and sealed the hearing. Now that there was actual evidence that the defendant had really been sick the whole time without treatment. In the end, the judge still ordered defendant to defend herself at trial, knowing she was too ill to proceed. The by any means necessary ordered continued from the judge every day through trial from May 30th until June 12th, the day the verdict was given. This is a violation of defendant's due process rights under the 5th and 14th Amendments of the United States Constitution and Article 2, Section 4 of the Arizona Constitution. This alone constitutes a new trial. Section B, lack of impartiality. The court precluded this defendant from presenting her case by not allowing defendant to argue objections, regularly denying sidebars, and not allowing her time to consult with her investigator and obtain documents from him prior to cross-examining witnesses. To begin, this defendant, in attempting to cross-examine the case agent regarding the investigation done at the scene by initial responding officers, was denied that opportunity. She cites in the transcript the minute mark for this. The initial responding officer spoke with a witness who provided a different description of the Jeep she saw during the incident. Defendant attempted to cross-examine the case agent when the state objected to the answer based on hearsay. The objection by the state was sustained. Defendant, even though not having been asked for a response from the judge, argued the statement was not being used for the truth of the matter, rather to show effect on listen. Defendant requested a sidebar and was denied. The same interaction occurred with another scene agent, David Ferrer, when defendant attempted to cross-examine him regarding what other neighbors told police they heard during the police investigation. A hearsay objection was sustained without allowing defendant an opportunity to respond. Lastly, defendant put on the record early in the case that her investigator, Jeff White, had been out ill. The court requested defendant's advisory counsel work with investigator White to obtain documents and exhibits she would need to cross-examine witnesses. Photos were received by advisory counsel and were not able to be printed in time to use during cross of Detective Ferrer. Those exhibits were attached as Exhibit 1. Defendant was also unable to admit Exhibits 192 through 194 as the state and the court continued to state she would be opening the door to her prior convictions. Additionally, the state continuously stated defendant's line of questioning relating to Melanie Boudreaux constituted a third-party defense. Yet, defendant never attempted to blame Melanie Boudreaux for the crimes. Defendant was simply attempting to cross-examine victim Brandon Boudreaux as to why he blamed defendant. She says she attaches Exhibits 192 through 194. Section C, Abuse of Discretion. Part 1, Denial of Rule 13.5 Hearing, that deals with the amendment of charges and objections to defects in the charging document. On May 29th, after reviewing jury electronic questionnaires, defendant requested a probable cause hearing on aggravating circumstances pursuant to Arizona Rules of Criminal Procedure 13.5a. The court denied the request, stating that defendant was not entitled to a probable cause hearing. 2. Not releasing the jury from the admonition on the record. After the verdict was read on June 12th, the court dismissed the jury so that the parties could discuss whether an aggravation phase would be presented. After discussion relating to the denial of the Rule 13.5 hearing, the court set a sentencing date and dismissed the parties without bringing the jury back into the courtroom to officially lift the admonition and dismiss the jury. 3. Allowing gunshot residue and DNA evidence without sufficient foundation and denial of right to confront witnesses. On May 3rd, the state filed a motion to preclude Brady material relating to crime scene tech Tammy Lachik from Gilbert Police Department, who collected material evidence from the alleged crime scene. Brady material showing that the witness Lachik was implicated in an incident that resulted in her resignation was disclosed by the state May 1st, even though the report was concluded March 6th. Because of the late disclose, defendant requested the court order the state to disclose the witness's employee file so the defendant could thoroughly investigate any issues that might be relevant to this witness testifying at trial set to begin May 29th. The court denied this request. May 25th, the state notified defendant that 2 pages of this witness's notes, which other forensic scientists would have needed to rely upon or had relied upon, were now missing and could not be provided to the defense. On June 3rd, in the middle of the trial, the state disclosed a letter from the witness indicating she would not be testifying. She marked this as an exhibit for appellate purposes. Defendant objected prior to each forensic scientist, 2 from Mesa Crime Lab and 1 from the Phoenix Crime Lab, to the witnesses testifying about analysis they completed based on the work conducted by witness Lachik. The first witness was Emmeline Sapinoso, who created a profile from the blood blots collected by this witness at the autopsy of Alex Cox. The second analyst was Vanessa Milkey, who testified that the blood blot profile of Alex Cox matched DNA swabs taken by witness Lachik from the Jeep Wrangler. Finally, analyst Kyle Mueller, who testified about the gunshot residue particles found inside the Jeep that were collected by witness Lachik. Those objections were denied. Section 2, Argument and Authority. The Arizona Rules of Criminal Procedure provide that a court may grant a new trial for any other reason not due to the defendant's own fault. The defendant has not received a fair and impartial trial. And that is citing Arizona Rules of Criminal Procedure. Section A, under Argument and Authority, Fourth Amendment violation medical evaluation. By forcing defendant to proceed with trial as her own counsel, deprived her of the right to effective assistance of counsel. There is no honor in forcing this defendant to defend herself sick. There is no honor in ordering by any means necessary to ensure that you will be the judge to preside over this high-profile case. There is no honor in threatening defendant over and over that you will inform the jury that she was convicted of prior murders. Where is the honor in this court system? Section B, lack of impartiality. A defendant may move for a new trial based on the court's lack of impartiality. She cites State versus Medina. While under the law, a trial court is presumed to be impartial and free from bias. This defendant can rebut this by the preponderance of the evidence by showing the court required her to present her defense strategy to the state before calling any witnesses, by denying defendant a thorough opportunity to present her case by preventing defendant from arguing objections, regularly denying sidebars, and not allowing her time to consult with her investigator and obtain documents from his prior to cross-examining witnesses. This court established a lack of impartiality. During cross-examination, defendant was not allowed opportunities or even asked for responses to state's objections. Defendant was continuously admonished not to speak over the court, yet when courts generally request a response from defense regarding objections, this defendant was not afforded that opportunity. When defendant attempted to explain why a statement was not hearsay because it established how the police investigated the case, the court spoke over defendant, telling her The objection was sustained. When defendant requested a sidebar, it was denied. By not allowing defendant to question witnesses relating to Melanie Boudreaux and how that could have impacted victim Brandon Boudreaux's thoughts on why he blamed defendant, this court showed a lack of impartiality. Any attempt to present defendant's case was met with threats of informing the jury about defendant's prior convictions. Section C, abuse of discretion. Number one, denial of the Rule 13.5 hearing. Again, 13.5 deals with the amendment of charges and objections to defects in the charging document. The court abused its discretion by denying a probable cause hearing under Rule 13.5 on the aggravating factors alleged by the state. There is only one sentence allowed for the crime of conspiracy to commit first-degree murder, and therefore the state should not have been allowed to argue aggravating factors. The court abused its discretion by denying defendant a Rule 13.5 hearing. Number two, not releasing the jury from the admonition on the record. The court abused its discretion by failing to inform the jury on the record and in front of the parties they were released from the admonition. Three, allowing gunshot residue and DNA evidence without sufficient foundation and denial of right to confront witnesses. Finally, by allowing the state to present evidence without a sufficient foundation, this court abused its discretion. Further, this defendant was denied her Sixth Amendment right to confront all witnesses. A clearly material witness was allowed to not be called, and then other analysts were allowed to testify to her work product in violation of Smith versus Arizona and the U.S. Confrontation Clause. Further, defendant was precluded from investigating witness LeChick's employee file to see if there were other issues that would be allowed as impeachment evidence during trial. The court failed to conduct an evidentiary hearing and only issued a minute entry stating that the events happened after she collected the evidence. By preventing defendant from concluding an independent investigation into witness LeChick and conducting an evidentiary hearing, it abused its discretion. Part 3 is the conclusion. The state of Arizona does not honor the Constitution of the United States. The state of Arizona does not honor the constitutional rights of the accused or even the civil rights of the accused. For this purpose, a new trial is required. This was submitted on June 23rd. So that is the new filing by Lori. I have a pretty good idea what the judge is going to rule, but we will wait and see officially what he decides. That's it for today. Hope you guys have a good rest of your evening, and we will see you soon.